Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property. Today, we are talking about the fourth of four questions in our series, holding interest in property and how government can take those interests away. So the Takings Clause of the U.S. Constitution, what is it? As a reminder, it allows government to take private property as long as government justly compensates the property owners. Another video pointed out that there are two kinds of takings, physical takings and regulatory takings. When we think about physical takings, we might be thinking about most about eminent domain, a topic that's covered in another video. But what happens when a regulation leads to a physical occupation? It's still a regulatory taking, but it may have such extreme consequences. It may be such an extreme measure that we take regulatory takings leading to physical occupations more seriously. Today, we're talking about a case involving an alleged regulatory taking leading to a physical occupation. The 1982 U.S. Supreme Court decision in Loretto versus Teleprompter Manhattan CATV Company. At issue in the case is a New York state law requiring landlords to allow cable companies to go onto their property and install certain hardware. This law essentially delegates to private cable companies the right to take and use property without just compensation. Property owners were only entitled to compensation determined by a board. So the plaintiff, Jean Loretto, who is she? She owns an apartment building in New York City's Morningside Heights. A cable company, Teleprompter, decides that it's going to put a 30-foot long cable on her roof. They do so, they attach it to the adjoining building as well. Initially, the cable didn't even serve the tenants in her building, but the tenants do have cable by the time the matter makes it to court. At the time, the board said that $1 was sufficient compensation for the cable because that amount would have been the equivalent that would have been received by transportation utilities. So the landlord here, Loretto, does not think that is enough. She has what I would consider to be a fundamental problem with the occupation of her property by other private parties. She doesn't argue that the law itself violates government police powers. Instead, she argues that it violates the Takings Clause. In making its decision, the Supreme Court, of course, looks to Penn Central, a key regulatory takings case considered in another video. Penn Central had been decided just 4 years earlier. There were 3 critical factors identified in that case that the court weighed to determine whether a taking had in fact occurred. First, the character of the government action. Second, the economic impact on the claimant. And third, reasonable investment-backed expectations. It's the character of the government action that matters most in this case. The court, with an opinion written by Justice Marshall, says that if the action is a permanent physical occupation of property, if the government action leads to a permanent physical occupation of property, that the other factors are essentially less important, maybe even meaningless, because the character of the government action is so invasive. Permanent physical occupations destroy the right to possess, the power to exclude, and the power to transfer. The court doesn't care whether the action, whether the regulation achieves an important public benefit or only minimally impacts the owner. The inquiry stops with the first Penn Central factor, which is the character of the government action. This rule, in this case, is a clear rule, what scholars call a per se takings rule. We discuss another per se rule in the Lucas case in another video. The court in Loretto, though, takes care to note that its holding does not affect those laws that require property owners to install smoke detectors, mailboxes, or fire extinguishers, or to otherwise comply with building code rules. It says that the New York cable rule is different because it required property owners to suffer the physical occupation of a third party. In his dissent, Justice Blackmun disagrees about whether these laws are qualitatively different than the cable law. He observes that all of these laws require property owners to install certain permanent physical facilities on their buildings. Moreover, he says, the mailboxes are filled by third parties, and the fire extinguishers may be used by third parties, firefighters who might enter a building. So we require property owners to follow certain rules all the time. And the New York rule on the cable is not really that different from other rules that aren't considered takings. The dissent goes on to argue that we should weigh all of the Penn Central factors and not have per se rules. As another example, what about the concept of reciprocity of advantage raised in Pennsylvania Coal versus Mann, which we discuss in another video? The tenants in Loretto's building certainly benefit. The cable company, of course, benefits. Even the landlord benefits because her tenants now have access to cable television. So she might be able to receive higher rents. What is the impact of Loretto? What is its aftermath? So as you can imagine, even though the damages can be minimal, lots of people want to describe their takings as permanent physical occupations, even if they're simply regulations that have led to this. At the Supreme Court, there's not a lot of logic to the post-Loretto decisions. For example, in the Nolan and Dolan cases we discuss in the video about exactions, the court says that the dedication of permanent easements were takings. But then it also says that rent control ordinances, and in other cases, that rent control ordinances, federal rules requiring utility companies to lease space on poles to cable companies were not takings. So again, a bit of a grab bag of post-Loretto decisions as plaintiffs try to fit their facts into Loretto. So I will leave it there. I would love to hear from you, whether through Twitter or through my website where you can sign up to my mailing list, and I will hope to see you next time. Thanks.